Well, happy Wednesday. Busy day yesterday when it comes to litigation against Illinois' gun laws. I'm Greg Bishop, Springfield's Morning News on 92.7 WMAY, Springfield's News and Talk. Follow me anywhere, Bishop on Air. You can do that on Twitter, where you might find the latest news articles I produce, or any kind of developing or breaking news. I'll post it there throughout the day. But of course, live here on WMAY, weekday mornings from 6 to 9. Thanks for tuning in. We've been tracking this gun ban litigation since ultimately the law passed on January 10th and was enacted. Then all of the lawsuits that were ultimately filed. But that's not the only thing being challenged. You've got challenges also now of the firearm owner identification card. And a case was heard here in Sangamon County yesterday in the state level courts to challenge the FOID card. And that's a challenge that was filed back in 2019 by Gun Save Life. Now, there was supposed to be a hearing on this back in April, but apparently a medical issue with a judge delayed that, and then it was brought to a hearing yesterday in Sangamon County, and they actually changed the judge, and then they had some oral arguments. Apparently, the judge did not ask any questions, however, did give an order for both sides to file proposed orders within 21 days. So now that clock is ticking. We'll see what those proposed orders might look like and whether or not the judge issues an expeditious ruling or where that'll ultimately go. But that's in state court. And that just deals with the firearm owner identification card. There are, 2.4 million FOID card holders in the state of Illinois. That's 2.4 million people that have an identification that had to go through Illinois State Police in order for them to buy and own firearms or ammunition. So the FOID card, Illinois is the only state with a FOID card, but there are 4 states altogether out of 50 that have some sort of identification requirement. So Illinois is definitely an outlier for the rest of the country. And it begs the question as to whether it's constitutional. So we'll hear from John Bach just what he had to say from Gun Save Life when I chatted with him back in April. And he shared that, since the Bruin case from last summer where the U.S. Supreme Court essentially said that, listen, courts have to weigh constitutional rights based off of text, history, and tradition, not off of any kind of balanced interest of the public good. So here's John Bach, again, laying out the arguments against the FOID card that ultimately are being made and now taken under advisement by the Sangamon County judge.
And, of course, there were no FOID cards in 1791, so there's no historical analog the state can point to for legitimizing this unconstitutional restriction of our rights to require people to register, to pay, to exercise their constitutional rights, their fundamental constitutional rights.
So the case heard yesterday, 21 days to get some kind of proposed orders from both sides. The judge will then consider those orders in crafting his final order in this case. Guaranteed, it's likely to going to go up to maybe an appellate court in state court, possibly to the Illinois Supreme Court, or it could get transferred to federal court. We shall see ultimately what happens with that. But again, that's just the one challenge of a FOID card requirement in state court. Let's turn our attention now to federal courts, where you had the Southern District of Illinois and the Northern District of Illinois give different rulings on a challenge of Illinois' gun and magazine ban enacted in January. And in the Southern District, you had consolidated cases where the judge there, he said that there's a temporary restraining order, that the plaintiffs met the burden, that he's going to issue a temporary restraining order against the state from enforcing the law. That temporary restraining order was immediately appealed to the Seventh Circuit Court of Appeals by the state, and they got a stay, meaning the temporary restraining order was reversed, or the preliminary injunction, I should say. The state-level courts have temporary restraining orders. The federal courts have preliminary injunctions. So the preliminary injunction from the Southern District was stayed by the Seventh Circuit Court of Appeals. In the Northern District, those judges, they sided with state and local gun and magazine bans. So now you have the Seventh Circuit. Earlier this month, the Illinois defense filed their briefs essentially laying out a string of arguments that firearms are much more technically advanced, they're much more dangerous, semi-automatic firearms are only used by criminals, And they also said that the bans are necessary because of instances of violent crime and mass shootings. Well, what's the argument against all of that? That was filed yesterday. You've got several filings that were filed, including from the Caleb Barnett et al. Case. And they have a good 70-plus pages here. And they make some arguments in their overview that the firearms and feeding devices in the law are arms, and that those arms are in common use for lawful purposes, including self-defense, and that there's no historical tradition of banning arms that millions of law-abiding citizens own for lawful purposes, and Illinois cannot save the law by pointing to some dramatic technological change or novel societal problem. And they go on from there. But if you look at the docket, yesterday the rest of the filings started coming through. The Javier Herrera case, they had to refile that. They had to resubmit after the court did not originally accept their filing. But you also have the filings from Thomas Magg and the Langley case. And again, we won't be able to see those. Once the document's approved, it'll be available on the docket. So we'll be able to review what Thomas Magg had to say. But I did reach out to David Sigale. He is the attorney representing Caleb Barnett in the case that's consolidated from the Southern District. So we will hear from him next in a conversation I had with him yesterday. So stay tuned. That's coming up here with Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. Let's get to the conversation I had with David Sigale. He is one of the lead attorneys in the consolidated cases from the Southern District of Illinois federal courts, now in the Seventh Circuit Court of Appeals. You had filings that are being made by plaintiffs after the states had previously made filings. Keep in mind, this will be heard in Chicago June 29th after reply briefs filed June 23rd. So here's David Sigale from some of my conversation with him yesterday, just to kind of get a lay of the land of where we're at.
Well, in a nutshell, we, and by we I mean the plaintiffs in our case, Harrell, Harrel, as well as the other, the two of the three other cases argued in the Southern District of Illinois back in April. There's a fourth one who will be chose to file something separate. Argued that in essence that the district court down in East St. Louis made the correct legal decision, and that when the analysis similar to what we argued in the district court, that when you do the proper analysis that the U.S. Supreme Court required in its Bruin decision back last summer, that the law doesn't pass constitutional muster, and that it really criminalizes a whole lot of constitutionally protected behavior and criminalizes a lot of law-abiding people.
So again, the states and local governments defending the gun and magazine ban, they say that the ban's necessary because of technological changes that made the weapons more deadly. They also say that these are owned by criminals for nefarious purposes, and I'm just paraphrasing here, but also that the increase of violent crime and mass shootings requires that states react and ban these types of firearms. I asked David Sigale, the attorney for the plaintiffs group down in the Southern Districts, to respond to that.
Well, the district judge weighed that question carefully and concluded it was not enough of a reason. And
the question was, do those concerns, increased technology, the lethality of these firearms, the violent crime, do those things trump constitutional rights?
Any gun crime is horrible, but the state is wrong in its assertions that that you just recapped right there. And we, put this in our response brief, that we're not talking about technological. We're not talking about new technology. We're talking about technology that's been around for hundreds of years.
And he also talked about the gun crimes, the violent crimes, the mass shootings that are happening, and how that's absolutely horrific, but yet it's not something new.
It's terrible, but it's not new. And that the way to solve this problem is not to strip the rights away and from and criminalize the behavior of tens of thousands, hundreds of thousands of law-abiding people in the state.
So David Sigale, again, one of the attorneys representing a group of the consolidated cases out of the Southern District of Illinois, now in the Seventh Circuit Court of Appeals. They've got the hearing that's going to happen June 29th in Chicago. When they come out with a ruling, that's unclear. The Seventh Circuit Court of Appeals, will it happen before January 1st, which is that date certain that if the law is not struck down and is allowed to stand, January 1st is that deadline for people who already have these firearms that the state has determined are banned. They have to register those firearms by January 1st or face criminal penalties. I asked David Sigale, is this going to be rectified and finalized before January 1st? What's going to happen here?
That's going to be hard to say, and I'll explain why. The first is that the Seventh Circuit, which now has all these cases from the Northern District of Illinois, Southern District of Illinois, they don't have a deadline to issue a ruling. So, in theory, the court can take as long as it wants, and the argument that's on June 29th, it could be well into next year before they issue a ruling. Having said that, the court, I believe, is obviously well aware of the timetable, and I believe in this case would work to issue an opinion expeditiously. But having said that, there is, for whichever side is unhappy with the Seventh Circuit's ruling, there's the option, of course, to seek Supreme Court review. And that alone means that there's a decent likelihood that the case will not be resolved by, within the next 5 months. But it's a two-part answer. I think the Seventh Circuit, I believe they will work to provide guidance, knowing the timetable. But the case won't be over technically and practically speaking when the Seventh Circuit rules.
So unclear as to whether or not we'll get a ruling. Possibly one of those the ruling could say, hey, we're striking this law down. Right? And that could come out of the Seventh Circuit Court of Appeals. If that happens, then it goes to the U.S. Supreme Court. It's expected that the state will file that appeal to the U.S. Supreme Court. But if the law struck down, that would be possibly before January 1st. If the law is upheld, then going to the U.S. Supreme Court could take months longer and possibly push us past that January 1st deadline to register firearms or face criminal penalties. So interesting where we're at in all of this, but just to share a little bit of what some of the sentiments are from those who want more gun control, we look no further than the White House. These are remarks by President Joe Biden on a campaign stump in Kentfield, California yesterday. Pretty long remarks. Again, it's a campaign event. The White House transcribing this, and the issue of the Second Amendment was part of the conversation where Biden says, I'm a Second Amendment guy. I taught it for years, 6 years in law school, and guess what? It doesn't say that you can own any weapon you want. It says that there are certain weapons that you just can't own. Even during when it was passed, you couldn't own a cannon. You can't own a machine gun. He goes on to say, this is the president. So what's the deal with the idea that is an absolute? I love these guys who say the Second Amendment is, the tree of liberty is watered with the blood of patriots. I think it's watered with the blood of patriots and tyrants alike. But either way, it's a pretty popular quote. Well, if you want to do that, you want to work against the government, Biden says, you need an F-16. You need something else than just an AR-15. The generic point I want to make is, and I'm going to end this because I'm bored myself now, but we have to make sure that we have some economic freedom, and he goes on. But really, the idea here, you have to have an F-16 if you want to go against the government. That seems to be a go-to argument that a lot of people have when you say the Second Amendment's there as a protection of the free state. It's a well-regulated militia being necessary for the security of a free state. The right of the people to keep and bear arms shall not be infringed. So the free state is not to be free from, deer or dove. It's a free state from criminal violence, from tyrannical government, from foreign companies or foreign countries. So interesting to hear these arguments back and forth. But again, the president also did just make some remarks not recently over the weekend where he said, God save the Queen. So where's that coming from? All right, it is Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY. Springfield's News and Talk. Find me anywhere. Just search Bishop on